I introduced myself yesterday, but I'll do it real quickly again. My name is Mitchell Yell. I'm from the University of South Carolina. I don't say might, could have, or I don't cut checks because I'm originally from Minnesota and I still have my Minnesota dialect, I think. I never did get a southern dialect, although I do like sweet tea. That's the one thing I really like in the South. Grits, not a big deal, but you know. So I'm quite used to the Midwest life and culture, and it's always nice to come back, except when it's in the winter. I kind of like to stay away during the winter, although now I notice it's as hot as here as it is in South Carolina. Maybe hotter, I think. So we've had a very mild summer, but we always have a mild winter, which is real nice. And 2 years ago, when the National CEC was here, I don't know if any of you were at that. It was a wonderful conference, but I think it was probably the coldest days in Indiana history, I believe. There was that polar vortex, if you remember that. It was unbelievably cold. But at any rate, I've been in South Carolina now for 30 years. I was originally intending to leave Minnesota for a couple years and go back to Minnesota. And I wound up staying in South Carolina, raising family, which is wonderful. It's a nice state. But what I've done over my career in South Carolina is mostly legal issues, but not from a law standpoint, because I'm an educator. My background is I was a teacher for 12 years in Minnesota in the Anoka Hennepin School District, and probably, I taught at all levels, elementary, middle, secondary, in special education, primarily with what in Minnesota, a long time ago, we used to call SLBP, because instead of just an emotional disability category and a learning disability category, they lumped it all together and called it special learning and behavior problems. And that eventually changed. But so that's been my background, mostly with children with mild disabilities then, and at a lot of different levels and in resource rooms and self-contained settings. So the way I've always kind of approached law is, what does it tell us as teachers? What does it tell us as administrators that we need to be doing? And what I'm going to be talking today about is making educationally appropriate and legally sound placement decisions. Placement is a funny issue. I know Jim was just up there and he did a little bit in LRE, but just a very little bit. And that's because it's really kind of a settled area of law. Although there was a decision, there was appeal to the Supreme Court a few years ago, otherwise the courts are pretty solid on what it is we have to do to make certain we are following the procedure of the law. So I put my email here, so I believe this on the jump drive, this presentation, and so you can access it. But if you have any questions or queries, or if I talk about anything you'd like a little further information on, please feel free to email me. Although if you do, in the subject line, put Indiana. I'm going to put that. We have a real aggressive spam filter at my university, so if you put Indiana, I'll do a delete. I'll make certain that anything with Indiana in the subject line goes through. So that's me, and just real briefly, how many of you are teachers? Special ed teachers, I mean. General ed teachers? Administrators? My goodness, school psychologists? We have a lot of people who didn't raise their hands, but I assume somehow you're educators. So this is what my plan is today. First thing I'm going to talk about what is placement. And placement is sometimes not what we think it is, the way it's defined in the law and the regulations. And then that's just going to take a little while. Then I'm going to talk about free appropriate public education, or FAPE, and placement, because courts have been pretty unanimous that actually our first consideration as educators is free appropriate public education. Placement is part of free appropriate public education, but FAPE is a very important consideration. Then I'm going to go through some placement requirements, the idea, and I'm going to talk about some policy letters because we all, in conference like this, we talk a lot about cases, and that's very important in hearings, because that's how the judicial system is interpreting what the legislative system says we need to do as special educators. But I'm going to also be talking about some policy letters from the U.S. Department of Education, because what they do, and if some of these letters come from folks like us who just have a question and send it into the U.S. Department of Education. We may get an answer. Our answer may be published. And these are called this is just policy. It's people in the U.S. Department of Education, very knowledgeable people in the U.S. Department of Education, saying, this is how we interpret what you need to do in order to be in compliance with the law. It's not quite as weighty as, say, a Supreme Court decision or any court decision, or a regulation or a legislation. But it's still really important that we understand those, because that's how the experts think we need to act to ensure that we're following the law. Then I'm going to turn to the courts, because back in the 80s and 90s, well, actually it's in the 80s, I would say mostly, this was the least restricted environment was a really big issue, and it made its way into the courts, and there were a lot of court decisions. And I'll talk about a very important decision out of the Seventh Circuit, which is your circuit. But essentially, they were sort of all saying very similar things about how we have to implement LRE. So I want to talk a little about that. Then we're going to talk about some errors in avoiding errors in placement determination, because there are a number of errors that can be made that are pretty serious, that, hearing officers, if they'll come across this kind of error, it's likely the school district will lose. So it's very important we avoid errors. And one thing I do have to tell you, I do in South Carolina, is I'm a state level hearing officer, which doesn't mean I hear cases at the local level. I'm sure, how many of you have been in due process hearing? Not too many. Well, okay. You don't want to be, let me tell you that. But what it is you're a little different in Indiana than we are in South Carolina, because you have what's called a one-tiered system. We have a two-tiered system. And that essentially means in Indiana, if a parent and a school district cannot settle a dispute, and Julie talked about her 4 C's: collaboration, creativity, communication. If you can't settle an issue at the IEP table, a parent has 2 options if they disagree with what the school district has done and the school district doesn't make any changes, and that is, one option is to file a state complaint, which every state has to have a mechanism where a parent can file a complaint with the state, and if you file a complaint, what the state folks will do is they'll look it over and come out and do an investigation. That's one option. A second option that parents would have would be to request a due process hearing. And those of you who've been in a due process hearing know what that's like. It's usually held oftentimes at the local school district, and in a one-tier system, you have your parents and their attorney, if they have one, on one side, the attorneys for the school district on the other side. You have your hearing officer. That's in South Carolina. In Indiana, of course, you have 3 at the state level. And what they do is they have a little chair and they have a court reporter. Generally what will happen is the attorneys will talk about their case. They will make their case through having witnesses coming up and introducing evidence, and then the other attorney will cross-examine the witness. And it goes on like that. I mean, it's like a court of law. Now in Indiana, what happens is these 3 judges get together, or these 3 due process hearing officers, I should say, get together, try and determine, well, who has the facts of the case, because usually the facts will differ. The parents say one thing and the school district says the other. They determine what the facts of the case are. Then they look at what the law requires. They look at Article 7, they look at IDEA, And then they decide who prevails. Is it the parents or is it the school district? And oftentimes, and I don't know, I haven't been any obviously in Indiana, but I have been plenty of them in South Carolina. They almost, and Jim kind of referred to this, it almost looks like the battle of the experts, because every side will have one or two experts and they'll come and testify. So your hearing officers have to weigh all this in making their decision. Now, in Indiana, if the party that loses doesn't like the decision, they can appeal either to state or federal court. And it's on 95% of the time nationally, the appeal will be to federal court because IDEA is a federal law. And then it goes through the court system. As Jim said, it could be the U.S. District Court for the Northern District of Indiana or the Southern District of Indiana. Then it could get appealed to the U.S. Circuit Court of Appeals for the Seventh Circuit. You're in the Seventh Circuit, so you really have to pay attention to those. Circuit courts, or appellate courts as they're often called, is right under the Supreme Court, so that's a real big deal. And then the highest level court, of course, is the U.S. Supreme Court, which just heard a very important, 2017 issued a very important case on FAPE, on free appropriate public education, in a case called Andrew F. v. Douglas County School District. So those are the two options. That's what happens in Indiana. You have your local hearing before your 3 due process hearing officers, and then if either party wants to appeal, that's when it goes to federal district court. And both Jim and Julie were mentioning there's not a lot of cases that go to federal district court in Indiana. I think I found 2 cases last year, and 2 cases that went to the state educational agency. That means the due process hearing officers issued a decision, and it just stopped there. So you don't seem to have a lot of litigation that I've seen, and certainly not about placement. South Carolina is a little different. We have what's called a 2-tier system. So we have the same local hearing as you guys do, only instead of 3 guys, it's just 1 person, the hearing officer. He makes the decision, then we appeal to the state at the 2nd tier, and that's what happens here in Indiana. But there's instead of 3, there's just 1. And that 1 person looks at the facts of the case that were determined by the hearing and the hearing officer's decision and decide if he decided correctly or not. If he decided incorrectly, they overturn it, or otherwise they affirm it. Then either party can go to the federal or state court. And in South Carolina, like every state, most special ed litigation goes all the way to the federal court. I mean, it doesn't stay in state court. Attorneys can make a decision, state or federal court, and they decide federal court. But that's what I do in South Carolina also, is I'm a state review officer, which is like what happens here with you, only I don't have to hear a whole case. I just sit down at the dining room table with a box of testimony and a box of exhibits and the decisions, and I decide, did the hearing officer make a correct decision? I just did one last month. I finished one that had 1,200 pages of testimony and 80 exhibits to go through. So the hearings are not fun things to do. And if you've ever been in one, which I know some of you had been, teachers wind up having to do a lot of research on what they're going to say and on the background of the case, and they have to, their attorney will often prepare them for cross-examination. It's not a fun thing to do at all. But that's kind of where this whole comes in. These were decisions that went beyond the hearing office. They went beyond the state hearing officers, and they went all the way to the courts. And in every case, in every circuit, including yours, LRE cases have gone all the way to the U.S. Court of Appeals for the Seventh Circuit, which is very, very important that we understand what that circuit was saying in terms of how we need to act in order to be in compliance with the law. So that's very important. And one of the things those court decisions have always said is there are certain big errors that we don't want to make when we're making placement decisions. So I'm going to talk about avoiding errors in placement determination and end up with making educationally appropriate and legally sound placement decisions. So that's what I plan to do today. And like I said, my email is is listed, so I'll be happy to respond to anything you have. Now, one of the things I want to talk about is the Education for All Handicapped Children Act is the law that was passed in 1975. And those of you who've been around as long as I have remember PL 94-142, we called it. The Education for All Handicapped Children Act was a federal law passed to bring kind of conformity to special education systems throughout the United States, because we had some states that would allow exclusion of handicapped children, then called handicapped children, now we refer to children with disabilities, and there were some states that had really good laws, some states that had no laws. And so the federal government thought we need one standard, so that's why in 1975 they passed the Education for All Handicapped Children Act. In 1990 that was changed, the name was changed to the Individuals with Disabilities Education Act, and that is the federal law that is virtually the same as Article 7. So everybody here talks a lot about the idea, and I'll talk a lot about the idea, but understand this, outside of a few minor differences, Article 7 is the idea. So everything you hear really applies, although it was a federal law, it applies to you. Now, one of the early folks in the Senate who was responsible or was a co-sponsor of the original Education for All Handicapped Children Act was a guy named Robert Stafford. He was a senator from Vermont, and he wrote, actually in 1978, he wrote an interesting article in the Vermont Law Review about what Congress was thinking about when they passed this law. Well, one of the things, he gave a lot of speeches on the Senate floor because, of course, things were very bipartisan then, and the idea passed overwhelmingly. But one of his pet issues had to do with placement, to ensure that our youngsters with disabilities would be educated with students who do not have disabilities, or as he said on the Senate floor in 1974 when they were talking about this law, we are concerned about children with handicapping conditions being educated in the most normal possible and least restrictive setting. For how else will they adapt to the world beyond the educational environment, and how else will the non-handicapped child adapt to them? So the concern, the placement concern very much at the, when IDEA, I'll just refer to IDEA from now on, was first passed was we need to make certain that students with disabilities are educated with students who do not have disabilities. And that is kind of where this whole placement thing arose. Now, the idea, unfortunately, and then the EAHCA, or Education for All Handicapped Children Act, now the idea, didn't really define placement. There was really not much of a definition. It talks about placement a lot, but it really doesn't define what it means. Well, that was up to the U.S. Department of Education. The U.S. Department of Education wrote the regulations to the idea. So, we have legislation, which tends to be very broad and not as specific. And so what the regulators do, or the regulatory agencies like the U.S. Department of Education do, is they write regulations that help implement the law. And they actually have tend to have more detail, and they help us more as educators in understanding what the requirements of the law are. And the regulations have every bit as much teeth in them as does the legislation. In other words, they have the force of law. And we have to make certain that we understand and follow the regulations. Well, the statute itself never did really. It talks about placement here. There's a lot of talking about placement, but it doesn't really define it. So it's up to the U.S. Department of Education, which was the regulatory agent, to fill in some more information about what exactly placement was. And this is how how they stated placement. This is how they define placement. Placement refers to the provision of special education and related services rather than a specific place, such as a specific classroom or specific school. So the regulations really don't, it doesn't concern itself so much with what school a child is in. It's concerned more with, is a child receiving a free, appropriate public education? And if it can't happen in a placement where disabled and non-disabled, you have to have different options. And so placement, therefore, is not a specific physical location. Rather, it is a point along a continuum. And what the U.S. Department of Education did is they developed this thing called the Continuum of Alternative Placements that I'm sure you're all familiar with. Article 7, or the regulations, I'm not sure if it's in Article 7 or the regulations, have a continuum of alternative placements too. We have to really understand what that means because that literally is where, on this continuum, a child will receive their FAPE, or their free, appropriate public education. Now, the guiding principle, or the fundamental premise of the idea and Article 7 regarding placement issues, that the idea, it's all about this collaborative team getting together and determining the child's fate. And then a collaborative team gets together and determines where the child can be placed, where they can best receive a free, appropriate public education. And we have to make that determination on an individual basis. We can't make it, it has to be made individually. We can't make it based on a category of disability, for example. And we have to make it in compliance with the mandate of the idea that requires that kids be educated in the LRE, or the least restrictive environment. Now, so it's very important to understand that prior to determining a student's placement, we determine a child's program. So think of what before where. You don't go into a case conference committee and say, okay, the first issue we're going to address is where we're going to educate little Johnny, and then we'll talk about the program. You can't do that. That's called shoehorning. That's fitting a child into a placement. You have to decide on the what before the where. You have to decide on the content of a child's education first. And that's why all courts have always said that a child receives a FAPE is really the most important issue. Placement in the LRE is secondary. FAPE has to come first. So I'm going to start out talking a little about how FAPE, a free, appropriate public education, and placement interact. And first off, this is a definition of FAPE. This has not changed since 1975. It hopefully will someday. Right now, this is the way the law was written in 1975. This is the way the law reads in 2017 about FAPE. This is exactly the way, with a few little nuances. Article 7 addresses FAPE. It's special education related services that are provided at public expense, which means, of course, we can't charge parents for anything. So that's in the IEP. So if we as a case conference committee make the decision a child is going to be educated in a more restrictive setting, we can't charge the parents for that. Even if we said your child needs to be educated in a private school setting, and that's in the IEP, we can't charge the parent for that. It's at public expense. The second thing about FAPE is it has to meet the standards of the state educational agency. In Indiana, of course, the education, your Department of Education in Indiana is your SEA. And if they have any rules about FAPE beyond what the federal government has, you have to follow those. And I've read Article 7 a number of times, and I think there's only one big difference. The federal government says that we don't have to have transition programming, according to the federal government, till a child turns 16. Well, in Indiana, it's 14. Article 7 says it's 14. Therefore, that's what you have to do, because that's what your state says. The state, on the other hand, couldn't say something like, we don't think a child needs transition services till 18, because then your state would be offering fewer rights to kids than does the federal government. So the state can't do that. So, but that's what that means. You meet the standards of the SEA. If the SEA has anything extra, you have to follow that. Some states like New York, in New York, they have a whole bunch of things extra that their teachers have to worry about. Indiana, you don't. You're kind of like South Carolina. We have a different transition aids. That's about it. Includes preschool, elementary, or secondary education. And then the last thing, and very important, is it's provided in conformity with the individualized education program. So whatever you have in the IEP essentially is an individual child's free appropriate public education, or FAPE. Now, as I said, courts were so concerned with the fact that we have to individualize education, is they said that the IEP, which is the FAPE, is the first thing we do. We don't do placement first, because we have to decide FAPE. In fact, the idea actually says a different team could do placement, a different team rather than the idea. But of course, that virtually never happens, because the IEP team can also be the placement team, and should be. Now, one of the things I showed this in my my slides yesterday is that same guy, Robert Stafford, that I talked about. He said Congress deliberately did not define this very clearly, because they left it to all of us in case conference committees to determine what a FAPE is for any individual child. In fact, he said we chose not to define FAPE. Rather, we made this baseline mechanism called the individualized education program that would become essentially a FAPE for a child. So it's very important about that. Now, there was a decision in 2017 I talked about yesterday, and you've probably heard it in virtually every session you've been in, called Andrew F. v. Douglas County School District. That was about FAPE. That was not about placement. But this is kind of interesting. They did make some references in the decision to placement, and there is, and I encourage you all to go. This is quite a long website, and you don't need to do that. Just go to Google and put U.S. Department Q&A Andrew, and you will get a PDF that the U.S. Department of Education put out on the Andrew decision. And remember, that is policy. It's not like the law. It's the U.S. Department of Education essentially telling us this is how we think you need to act in order to be in compliance with this, the new FAPE standard of the idea as announced in Andrew. And that was by the U.S. Department of Education. As I said, this document, it's probably about 5 pages long. It's a document that has 21, it's divided into 3 parts. The first part describes the Andrew decision. The second part has 21 questions that would be important to educators in understanding the decision. The third part has answers to the 21 questions. And in the question and answer session, they say specifically, I think it's question 17, yeah. They say, how does the Andrew F. decision affect placement? And that's what we're, of course, going to be talking about. They said 3 things about this. Number 1, the IEP team or your case conference committee must determine FAPE first and then decide what placement can we provide a free appropriate public education. So a real big mistake, and one we'll talk about in avoiding, is this idea that we have to talk. And I have been at IEP meetings, and I'm sure you have too, where the parents might want placement discussed and said, could we talk about placement? yes, we will talk about placement, but not until we first address what does your child need. So you must remember that. That's an important thing. FAPE comes before placement. The second thing they said is there's no one-size-fits-all approach to educating children with disabilities. Rather, placement decisions must be individualized and made consistent with the child's IEP. So here again, FAPE comes first, and then we decide the placement. Third thing they said is placement in regular classes may not be the least restrictive environment for every child with disability. And Jim just talked about that. And he used MRE, I think, most restrictive environment, he used in one of his slides. Well, what the U.S. Department of Education folks said is placement in regular classes, it doesn't have to be in the LRE. It could be in, again, the MRE or more restrictive settings, but in that case, you have to use this thing that the U.S. Department of Education created called the Continuum of Alternative Placements to meet the needs of the child. In other words, placement is where we decide the child can best receive a FAPE. So that was in this question and answer document. And again, it's a really good document to explain this decision. But essentially what they were doing is just really announcing what it was that they talked about way back in 1975, because really the placement decisions did not change a whole lot. And excuse me, I've got to get my time here. That's, there we go. So what are those placement requirements of the IDEA? Well, number one, you have to remember that it's all about a team approach. It's all about collaboration. That is, it's a team of knowledgeable persons, including a student's parents, who are knowledgeable about the student, obviously. The meaning of the evaluation and the placement options have to decide the placement. Now, that is not the same. The IEP team consists of your LEA rep, the special ed teacher, the general ed teacher. The law itself is not as specific. It doesn't say it has to have all the different folks that the IEP team does, but the placement decision is almost always made by the IEP team because that meets the placement requirements of the IDEA. Now, here's another requirement. The placement must be determined annually. So when we do our annual case conference review, that is one of the things we have to review. We have to review the child's placement, and again, the idea, or the regulations actually, also say base this reconsideration of the placement on the child's IEP. So again, the idea that you have to decide upon FAPE before you do LRE. Another requirement in the law is that this is actually in the regulations, this language I use, but it is in the law too, that students with disabilities should be educated in the school that the student would attend if he or she was not disabled, unless the student's IEP team decides otherwise. So what that means in essence is homeschool is definitely preferred, but it's not a requirement, absolute requirement, that we can decide to place a child in a different school rather than the home school. But again, it's kind of the presumption we'll have is that children will be educated in their home school, but we can decide otherwise. Also, when we make a placement decision, we can address issues of the child's behavior. Or does the child's behavior interfere with the learning of other children? And that could be, like in one case I'll be talking about later, that could be that they take so much of a teacher's time that we as a team determine a different setting or placement might be needed. So, or if they behave in such a way that is so disruptive to the classroom that a different setting may be needed. Those are legitimate decisions. The regulations say we can consider those decisions. Also, before making such a determination, though, we have to give full consideration to the continuum of alternative placements and using supplementary aids and services to accommodate the child in the general ed setting. Although one of the things Jim talked about, and I don't think he used the term supplementary aids and services, but it's a very serious thing to move a child to a more restrictive setting. And the law says before we make that, we must consider supplementary aids and services. So let's say you're, as your case conference committee, you've met and you're determining that a child's behavior impedes the learning of other children, and on the basis of that and the child's FAPE, you decide, well, we're going to move a child to a more restrictive setting. That's fine to do that, but you have to make certain that you've considered the full range of whatever you can do to keep the child in the less restrictive setting. Just a couple more rules. Placement must be made in the LRE with the least restrictive environment, and I'll talk more about that in a second. But that refers essentially to the setting closest to the general education classroom, or the most normal type setting. We kind of always assume that children should be, as I said, integrated with non-disabled children to the maximum extent appropriate. And that means generally the least restrictive setting is obviously the classroom, in the general ed classroom, but we can move children to more restrictive settings if that's what they need to get a FAPE. So again, the most important consideration we make is what is the FAPE for a child that we write in the IEP. In other words, what does the child need? Now, the LRE requirement actually, this is the way the statute, the idea, Article 7 lists the, talk about least restrictive environment. There's two parts to the least restrictive environment. The first part is to the maximum extent appropriate, students with disabilities should be educated with children who are not disabled. So that is where we start. That's kind of our baseline when we make placement decisions, that kids should be integrated. Non-disabled, disabled kids should be educated together. But then the law goes on to give us a different option. It says if a child cannot receive a FAPE, that we can consider more restrictive settings such as special classes, special schooling, or other removal of children from the general education setting, but only if we've determined as a case conference committee that education in the general education classroom with supplementary aids and services cannot be achieved satisfactorily. Now that is what a man named Rudd Turnbull back in the, well, I actually did this in the 1970s, wrote a book in which he referred to the LRE as a rebuttable presumption. So remember, LRE consists of two parts. It says all children should be educated with all children with disabilities should be educated with non-disabled children to the maximum extent appropriate. That's what he called the presumption, that we're going to educate children in integrated settings. Well, national data shows probably 90% of all kids are educated to some degree with non-disabled children. So integration isn't really that much of a problem. But, so that's our presumption. Whenever we consider placement, we start from the notion that disabled kids should be educated with non-disabled kids. Now, if we decide that's not appropriate, that a child will not receive a FAPE in that setting, we have a means to Turnbull called rebut the presumption. And the means is this. The means to rebut the presumption, we can move a child to a more restrictive setting, but only when the nature, severity of the disability is such that education in the general classroom with supplementary aids and services cannot be achieved satisfactorily. So presumption, that's where we start, but we do have a means to rebut that presumption. Now, if we decide that we're going to rebut the presumption, and Jim actually talked about this to some extent, we have to, if we decide we're going to move a child, we've decided the child's fate, and we've decided this is where the child will best receive a free, appropriate public education. We can't do it in the general setting. And say if we decide to move a child to a more restrictive setting, we have to remember that we need data. You know, Jim said that data is the gold standard, and it really is nowadays. Progress is the gold standard. The way we prove progress is through having some kind of data. So if we have data, what we need to be convinced of and have documentation of is the student is not progressing in that site. Now that doesn't mean we absolutely have to educate a child and in the general ed setting first, but it's a pretty strong indication, the law and the regulations. We should try the general ed setting first, and we should try supplementary aids and services and document those. So we start out with that presumption, and we use supplementary aids and services. We've tried them. We have shown we made good faith efforts to maintain a child in the LRE. We just couldn't do it. It just did not work out. We made the good faith efforts. The child is not getting a FAPE in that setting. We then have to move a child to a more restrictive setting, and we want to keep data to show that that more restrictive setting is the student is making progress in it. So especially in cases where parents absolutely intend or really advocate for the general ed setting, and you think that's not going to provide a FAPE, that is a decision the team makes together. And if it's the consensus of the team is we need a more restrictive setting, you really need to have evidence that the child has not been progressing in the general ed setting. We've tried, we've made good faith efforts, in terms of the different things that we've attempted. We've documented those because, as Julie said, this is special ed's all about documents. So we have to have records of that. We can move a child to a more restrictive setting, but we want to make certain we continue to monitor the progress. So I think the way Jim said it is we have to show that the school has really tried and that the more restrictive setting is beneficial. Those are real important considerations. Now, this was a continuum that was developed by the U.S. Department of Education back in 1975, and these are the less restrictive settings toward the top of the continuum. The more restrictive are on the bottom of the continuum. Now, when this was developed in 1975, it was actually taken from two articles written, one by Maynard Reynolds, one by Evelyn Dino, and they talked about this thing they called a cascade of services that all special ed kids should, if we decide to move children in a more restrictive setting, we have to have this cascade. Well, they called the continuum. That means that we start out with a regular classroom. That's the presumption, the general education classroom. However, if that is not, if we can't deliver FAPE to the child in the general ed classroom, we can move them to more restrictive settings. And the next step of the continuum, the U.S. Department called special classes. Those are generally special classes in the home school where the child spends 50, 60% of the day. That's the federal definition kind of special classes. The next more restrictive point on the continuum are special schools. And special schools are kind of going the way of the dinosaur. But, and I'm not sure about Indiana and Indianapolis, but in South Carolina, most states still have a school for the deaf and blind. That would be a special school. That would be a more restrictive option. In my hometown of Columbia, or my town of Columbia, where I live now, they used to have a special school for youngsters with emotional behavioral disorders, and many school districts do. That would be the third step in the continuum. And then the last step is hospital or institution. So if a child goes to an institution or has to be hospitalized, that's considered the most restrictive. And many courts have actually said, if you're putting a child on homebound, that's probably down here too. Why? Because when you get here toward the end, there is less opportunity for a child to be integrated with non-disabled children. So these are the more restrictive settings. And Dino and Reynolds' idea with a cascade of service in the 60s and 70s, and then the continuum of services, is that we always start there, up at the least restrictive setting. And that's where we want to educate children. But if we determine as a team that more restrictive settings are needed, then we can move down to MREs or more restrictive settings. But the idea here is that as soon as a child is receiving a FAPE, we try to move them back to the least restrictive settings. So every school district has to have those continuum options. That doesn't mean you physically have to have them, but it means if a child needs a special school to receive a FAPE and you don't have one in your school district, you must be able to contract or somehow find that setting and place the child in that setting so they do receive a free, appropriate public education. The continuum has been, like I said, a really important part of LRE, as well as placement. And in fact, there have been cases in which courts have ruled against school districts because they skipped around the continuum. There's one case in San Francisco where they went from regular classes all the way to special schools. And the court essentially said you skipped a step on the continuum. So that continuum is not to be, it's not an option of a menu of options. That's the way you have to go through the continuum if you decide a child needs a more restrictive setting. Now, in terms of extracurricular activities, non-academic services, the regulations also talk about how that should be in the least restrictive environment. In other words, that you should be able to educate, even in non-academic settings, students with disabilities should be integrated with non-disabled. So for example, here's what the federal regulations say. In providing or arranging for the provision of non-academic and extracurricular services and activities, including meals, recess periods, and services and activities that LEAs put on, schools must ensure that each child participates with non-disabled children in the extracurricular services and activities to the maximum extent appropriate to the needs of that child. The school district must ensure that each child has these aids and services determined by the IEP team to be appropriate and necessary for the child to participate in non-academic settings. Now, I know one of the things Jim was talking about was in terms of sports, and he had talked about his conversation with a coach and a special ed director. And many people misunderstand this, and it was kind of it became a big issue about 5 or 6 years ago when OCR put out, OCR is the Office of Civil Rights in the Department of Education, put out a policy letter on educating students with disabilities, or the requirement that students with disabilities participate with general ed settings in extracurricular activities. And folks who interpreted that to mean, oh, that means we have to have students with disabilities on the high school football team or on the high school basketball team. No, that's not what it meant. And they were actually talking about Section 504, and they were saying students with disabilities must have the same opportunities to try out for sports. But because, sports and many extracurricular activities have certain skill requirements, well, regular ed kids may not have those skill requirements and don't get on the team. Same with special ed kids. They may not have the skill requirements to be on the high school football team. And so that's fine if you don't do that. But you have to give them the same opportunity to try out. One of the things Jim was talking about is saying that a child with disabilities, we're not going to allow them to try out, or I'm not going to allow her to try out. Well, you can't do that. You have to give students with disabilities the same opportunities to participate in all extracurricular activities as you do non-disabled students. It doesn't mean they have to participate. It means they have to have a chance to participate. And that is somewhat similar to this. This is not saying you have to have children on sports teams, but you must allow them to be involved in non-academic activities and extracurricular activities with non-disabled children. Another big issue that the Department of Education talked about in terms of placement is, where exactly does a resource room fall in the continuum? So where is resource room there? Well, a resource room is considered, for purposes of law, part of the regular or general education setting. In fact, the resource room is considered to be a supplementary aid and service. So this is what the Department of Education said about that. Resource room and itinerant instruction, or teachers moving around between different settings, are viewed as supplementary aids and services provided in conjunction with the general education placement. So in other words, we don't see cases where parents say, I don't want, well, you might see cases like this, but they won't go very far, where a parent would say, I want my child only in the general ed classroom. I don't want any resource room. Well, that's certainly their option to do that, but you've got to remember that in terms of what the law says, the placement in a resource room is not more restrictive than the general ed classroom. It's viewed as a supplementary aid and service. Yes, ma'am. If the important thing from the federal law, and I would think this is true of most states, is that if the purpose of the study hall is to provide additional help, but the child is really a general ed student, that would be, in essence, for the purpose of the regulations, the supplementary aid and service. You're not choosing a more restrictive option for that child. Also, the IEP, if we decide that we're going to move a child to a more restrictive environment, we have to explain why. And the regulations say it must include explanation of the extent, if any, to which a child will not participate with non-disabled children in the regular class and extracurricular and non-academic activities. So in other words, when we talk about the presumption that all children should be in the LRE, if we're going to place a child in a more restrictive setting, we have to provide an explanation for that in the child's IEP. So anytime a child is removed from a general education setting, that we have to provide that explanation, and we cannot make that move to a more restrictive setting according to the regulations just because of the we're unable to provide the supplementary aids and services. And this is the language they use. It's a little confusing, but a student with a disability may not be removed from an age-appropriate general ed classroom solely because of modifications needed in the general ed classroom. So if we can educate the child there with supplementary aids and services in the general education classroom, that is where we have to educate the child. Okay, now, in the 1980s, there we go, we had a number of court cases on least restricted environment. It was a pretty big issue. Virtually every circuit in the country had cases about LRE. Now, we don't see a lot of cases like that anymore because, like I said, most circuits have pretty generally accepted rules that we must follow, including your circuit. Although, as I'll show you, this is a map of the circuit court boundaries. And of course, you folks are up here in the 7th Circuit. I'm down here in the 4th Circuit. And what is important to remember about that is these decisions that come out of the 7th Circuit are very important because the one court that has more power, I guess, or influence is the United States Supreme Court. Because when the Supreme Court makes a decision, all the circuits are bound to follow that. So one of the things, and I'll talk about this in a minute, in the 4th Circuit, we have a certain LRE rule that we have to follow that came from a decision called Ronker v. Walter, which was many years ago in the 6th Circuit. Our circuit just adopted that. So that means I, as a hearing officer, if I have an LRE case, I have to use what my circuit adopted, which is the Ronker standard or the Ronker test. Now, let's say a decision comes out of South Carolina here. It goes through due process hearing levels, winds up in the U.S. District Court for the District of South Carolina. And they call them the District of South Carolina and the District of Indiana. Let's say it's in South Carolina and it gets appealed. If it gets appealed to my circuit. My circuit is the 4th Circuit. But that doesn't just cover South Carolina. That covers South Carolina, North Carolina, Virginia, West Virginia, and Maryland. So that is a very important decision because I have to follow that as not only as a due process hearing officer, but as a teacher, administrator. That is how that court, the 4th Circuit Court, says we have to make that determination. Because it essentially says lower courts have to use the same standard. So in other words, and due process hearing officers, we will use the same standards. So it's very important that I understand what the 4th Circuit is telling me. Now, if you're in the 7th Circuit and the 4th Circuit makes a decision about LRE, that doesn't mean anything for you because you're in a different circuit. Because my circuit, 4th Circuit, it only applies there. It doesn't apply up here. Now, it's very likely, if it's a very important case and a very good decision, that it may have some sort of persuasive value if a decision comes up in the 7th Circuit that is similar, but they don't have to follow it. So what we often have are different circuits saying different things about FAPE and about LRE. Now, with the U.S. Supreme Court's decision in 2 FAPE cases, Rowley case and the Andrew decision, that applies everywhere. So all lower courts throughout the United States have to use the Rowley-Andrew test in determining FAPE. All hearing officers have to use the Rowley-Andrew test. But the Supreme Court has never heard a case on LRE. And it's not because there's been appeals of cases to the Supreme Court, but they just never heard one. So there's no one set standard across the entire United States. There are different standards. So it's kind of important that we understand what our different standards are. Now, there are really 2 very important decisions about least restricted environment that tell us how we have to make these decisions. One of them was out of the 5th Circuit, which is the circuit Jim Walsh is from, because he's from Texas. The 5th Circuit, in a case called Daniel R.R. v. State Board of Texas, or Independent School District, made a decision on LRE that was a very good decision. And it wound up being adopted in a number of circuits. You can see all the purple circuits here, the 10th Circuit, the 5th Circuit, the 11th Circuit, the 3rd Circuit, and the 2nd Circuit adopted this Daniel standard. And what's important about that is if you live in one of these circuits, like you lived in Colorado, that's the law in Colorado. You have to follow the Daniel decision. But the other important decision I was talking about was out of the 6th Circuit. That 6th Circuit made it, they had a decision, actually it was probably the first LRE decision at a circuit court level called Ronker v. Walter. Now that's been adopted by other circuits. That's been adopted by the 8th Circuit, and that's been adopted by the 4th Circuit, and it originated in the 6th Circuit. So I'm in the 4th Circuit. I have to follow the Ronker decision, or if school districts in my jurisdiction in making placement decision would be best advised to follow the Ronker decision. Now, so those are essentially the two major standards. There's the monster 9th Circuit way out here has kind of their own standard, which sort of took the two and put them together. And we're going to talk about that, of course, because we're not from that area. But your circuit in the 7th Circuit, you have no standard. And I'll talk about that in a case called, well, I'll show you the case in a second. They said, we don't need a standard. This is what we think school districts need to do to adhere to the law in terms of placement and LRE. So they said essentially things very much like the court in the Daniel test said, but they didn't actually adopt the Daniel test. So we'll talk about that because that's the big one for you. And then the 1st Circuit kind of didn't come up with anything either. So what I'm going to do is we're going to go through these. I'm going to talk a little about this, more about this, I guess, the Daniel test, because that's really very close to the test that is applied in the 7th Circuit, which means if you have a dispute with parents that you can't settle at the IEP, and it goes to the due process hearing level, and then winds up, let's see, 1145, okay, and then winds up in the courts, you pretty much have to follow that decision. The Daniel decision was very important. Now, let me go back to this first. The first decision you ever heard was the Ronker decision. That's the decision I have to follow in the 4th Circuit, and it's really a decision that is kind of intrusive because this involved a young boy named Neil Ronker, and Neil Ronker had Down syndrome and relatively not serious behavior problems, but did have problem behaviors, and it wound up going all the way to the United States Courts of Appeal for the 6th Circuit. And what they said is the idea does not require mainstreaming. The courts have always used the term mainstreaming. It does not require mainstreaming in every case, but the requirement that mainstreaming be provided to the maximum extent appropriate is a very strong congressional requirement. That is, in essence, the presumption that I was talking about. And they said whenever a court or a hearing officer in the 6th Circuit gets LRE decision, this is what they have to do. They have to decide whether a proposed placement is appropriate under the Act, and how they make that decision is if you're using a more restrictive setting, you have to ask, could the services that allow a child to receive a FAPE in that more restrictive setting, could we take those services and transport them, or could they be portable to the extent that we would provide them in a general education setting? And this decision was in 2018, a case called LH v. Hamilton was upheld. So in the 6th Circuit, the 6th Circuit, the 8th Circuit, which are all these, and my circuit, we have to follow this Ronker test. In other words, before we place a child in a more restrictive setting, we have to ask ourselves, can we take what made that more restrictive setting appropriate, and can we just move it into the general education setting. Now, a number of courts have decided that's courts getting a little too much in the way of educators, because that place courts or judges and saying, well, do I think that that could have been transported? So what happened is only a few circuits adopted that, and then this case in the Fifth Circuit came along that said, these are the things you have to do to make certain you adhere to the LRE in all these cases that follow, all these circuits that follow the Daniel test, the 10th, the 5th, the 11th, the 3rd, and the 2nd. And that is the first thing a judge or a hearing officer is going to do if parents in school districts cannot agree on placement of a child, is the judge or hearing officer is going to have to ask themselves, has the school attempted to accommodate the child by providing sufficient supplementary aids and services and program modifications to keep the child in the general ed setting? So that, in essence, is exactly what the law says. Then, if a student cannot be accommodated in the general education setting, has the school mainstreamed the student to the maximum extent appropriate? You know, are they integrated with students with disabilities in other settings? So that Daniel standard was adopted by a number of districts, but your circuit did not adopt that case. In 2002, there was a decision in the Seventh Circuit called Beth v. Von Clay. Beth B. was a young girl with Rett syndrome who was 13 years old. From the age of 7 to 13, she was served in the regular classroom with a paraprofessional. But when she turned 13, the school district recommended that Beth be educated in an educational life skills program, which was a more restrictive setting in a different school. It was a small student-teacher ratio. There's only like 6 to 8 students in it. There was mainstreaming sometimes in computer classes. Beth would go back for recess. She would be in social studies classes. And they did that kind of reverse mainstreaming program there where the teacher would go into the class. But essentially, she was educated more or less in a self-contained setting, this ELS program. Parents disagreed with that, took the case through the due process hearing, went through due process hearing to the federal district court. I think in the northern district, you have your state's divided into 2 districts. And here's what the Seventh Circuit said. First thing they said is they looked at the Ronker test and they said, that's too intrusive. You know, judges and hearing officers shouldn't be in the position of second-guessing case conference committees or IEP teams that may make placement decisions. They also looked at the circuit court decision in Daniel, which most circuits have adopted, and decided not to adopt that. Instead, they adopted a test that they didn't call a test. But every hearing officer, every judge who gets a case out of your school districts involving placement have to do this. So it's very important, and it is really a test. The first thing is to understand that the court said, we understand every student's educational situation is going to be unique, but we don't find it necessary to adopt a formal test for district courts and hearing officers to apply when they're deciding LRE cases. The law itself provides enough framework for our discussion. So instead of doing a test, if we get a case on LRE, we will ask whether education in the homeschool or conventional school was satisfactory. And if not, whether reasonable measures would have made it so. So in other words, it's very much like the Daniel test, and it's very much like what Jim talked about. In essence, but one of the things about the Seventh Circuit is, in this circuit, judges are less likely to overturn hearing your decisions as a case conference committee. But they are going to look at the factors that yes, number one, this is a presumption. Kids should be educated in less restrictive settings. And if you do have to move them, did you make those reasonable measures to try and keep the child there? In other words, if you looked at that one slide that Jim had on when you decide on MRE, I think the slide was titled, you ask yourself, does it, begin with the presumption that all kids should be in the general ed setting, but if you have to move them to a more restrictive settings, you follow the law. Essentially use that rebuttable presumption. Can we educate a child in the general ed setting? If your answer is no, can we use any supplementary aids and services to educate the child? If the answer is no, you can move the child, but you need to have documentation to that effect. So in your circuit, you have less of kind of an onerous federal court case hovering over you than I do in the Fourth Circuit, where I have the Ronker. Now, but if we look at the Daniel RR, the Ronker, and the other all together, there are certain reasons school districts win in these cases. Number one, all of the cases in which school districts have won, and not just Daniel RR, but pretty much all the cases at the circuit court level, the school has made good faith efforts to include the child in the general ed setting. They involve the parents. Remember how important, going back to what Julie said about collaboration, communication. This is all about a collaborative team makes this decision. That doesn't mean if the parents want a decision that the team's consensus is will not provide a FAPE, you can use a more restrictive setting, certainly. But if the parent is in a disagreement, as they were in all these cases, one of the things that bailed the school districts out every time is they had excellent documentation. So you want to keep good documentation, especially if you think there's issues that may not be resolved. And then in all these cases in which the Daniel case, the Beth B. Clay case, and the Ronker, when students were educated in non-integrated settings, they were given opportunities to be educated in integrated settings. If it was just math, if it's just reading or social studies or recess, there was some option for integration with non-disabled children. Now, if we look on the other hand at the school districts that have lost, in all these cases, there's certain things that we find over and over again. One of the things that causes school districts to lose is they don't make what courts call good faith efforts to provide those supplementary aids and services in the general education setting. Another reason that school districts lose, and I talked about this earlier, is failing to consider the continuum. So if you decide on a more restrictive setting, you have to do it lockstep. You don't skip around the continuum. And the last reason that they lost is the schools did not have proper documentation of their efforts. So they didn't document that they had tried supplementary aid and services. And I remember one case out of the Third Circuit, it was called Oberti, a child also with Down syndrome had very serious problem behaviors. And the team, based on the seriousness of his problem behaviors, moved him to a more restrictive setting, which would have been fine, but they didn't have any documentation of the behavioral interventions they had done in the general ed classroom. And I remember reading part of the transcripts of this case, and one of the attorneys, a guy named Reed Martin, no, it was not Reed Martin, was questioning one of the teachers with the special ed administrator and said, well, you said you did all these behavioral interventions in the general ed classroom to keep Raphael there in that setting. Could I see them? What were they? They had no documentation. They said, the administrator said, well, we didn't have the documentation, but we did it. Well, again, for a court, that doesn't mean anything, because as Julia said, documentation is very important. Now, given those three decisions, there are more decisions, but those three decisions are the big ones, there are certain errors in determining placement we have to really be aware of. One is we don't want to make placements unrelated to an individual child's needs. And I've listed a number of different policy statements here. We can just go through really quickly. Remember, policy doesn't have the force of law, but this is what the Department of Education tells us. In a case, and what they do is if you have a question, you can send a letter to the U.S. Department of Education, the Office of Special Ed Programs. They may answer you, and they may publish it. And if it's published, it becomes a policy. So this is a letter called Letter to Cohen, which is essentially an OSEP policy, or Office of Special Ed Programs. And they said the law requires the first consideration be given to placement in the general ed classroom with any necessary supplementary aids and services to make that placement successful before deciding on MRE, or most restrictive placement. So that is our policy statement that really mirrors what the federal government is saying. Our presumption has to be that all students are to be educated in general education settings. This one's an interesting one because they talked about, and Jim mentioned this too, this was about a charter school. Charter schools have the same exact requirements regarding what they have to do. It's a little different how they have to do it. But placements must be based solely on can't be based solely on the child's disability in a charter school. And we certainly know that can't be in a public school. So you couldn't say, for example, you may have a school for youngsters with autism, but you don't start out by saying, well, Johnny's going to be in the autism school. Now let's develop the program. You develop the program and say, where can we best meet that? Well, we have a school that, and then explain the school, and maybe you choose that as an option. But you always have to start out with a placement. You can't make decisions based on any one factor. This policy letter said you can't use severity of disability, category of disability, availability of special ed services, or administrative convenience, or space in the school. We don't have space in the school. You can't make decisions on that. You have to make decisions based on the individual child. Another error is failing to adhere to the continuum, and we don't need to talk about that because we talked about that in terms of the court decisions. But essentially, a student with disability, this is kind of an interesting policy statement. We know that students with disabilities have that presumptive right to be educated with students without disabilities, but according to OSEP, that's the Office of Special Ed Programs in Washington, D.C., a student with disability need not fail in the regular education environment before we decide or consider placement in a more restrictive setting. They don't need to be placed there and then fail. We need to consider those special supplementary aids and services. And for all intents and purposes, a child should probably start there, but we don't have to keep them in there until they're failing. Let me go to the next one. This is probably one of the worst things we can do in schools is called predetermination. That's deciding on a child's placement before we have the case conference committee. In other words, trying to essentially finalizing a placement decision before we have the final meeting. This was a case, and it wasn't in your circuit, it was out in the Ninth Circuit in Las Vegas, but they did a really good job of defining what predetermination is. They said anytime you are making a determination on placement prior to the final IEP meeting, including times when you just say, well, no, all our children with emotional disabilities are educated in this setting. That is, and you're unwilling to consider options, that, according to the Ninth Circuit Court of Appeals, is illegal. You can't make those determinations prior. Predetermination can also be made in terms of fate. So anytime you decide beforehand what the placement option is going to be and present it to the parent as this is where the child's going to be, that is in essence illegal. The decision has to be made at the IEP table or by the case conference committee. Now that doesn't mean you can't discuss placement issues informally as a team. You just can't present it as a final you can't present it and say it's sort of a take it or leave it. You can certainly discuss, you can certainly prepare, just don't predetermine. These are a couple cases that have shown that parents have, one of the things parent advocacy attorneys will often do is try to show predetermination. Because if they do, that's usually the end of the issue. You will often lose a couple cases which have said that, yeah, you can discuss these things. You can discuss placement issues. You just don't make the final decision. As one court in Virginia said, school officials must come to the IEP table with an open mind. However, that doesn't mean you need to come with a blank mind. You can discuss, but you just don't make the final decision. Another error is placing a student prior to determining programming. That is what we call shoehorning, or what attorneys often call shoehorning. In other words, we're saying, no, all our students with emotional disabilities are going to go to Olympia Public School. That's where we educate our youngsters with emotional disabilities. That would be placing prior to determining program. So you have to determine the program first. We've talked about those. We've talked about the way you avoid shoehorning is by discussing programming before placement. So that's not a big issue. Now, in terms of making appropriate placement decisions, this is what we need to do. When you have your assessment, you decide on your programming. Then you decide on your placement. Don't do it this way. That would be shoehorning. Where you do the assessment, then go over here and decide placement. Then you go back to programming. That would be illegal. You don't want to do that. What you want to do is determine FAPE, which means you write the IEP, look at the present levels, write your measurable annual goals, determine your services, determine how you're going to monitor a student's progress, then move to determining the appropriate placement. And for 94% of the students with disabilities nationally, that means general ed setting with supplementary aids and services, such as a resource room. So when you determine placement, you ask, in what placement can we determine FAPE? Can FAPE be delivered? Now, if it can't be delivered, and you as a team believe a more restrictive setting is necessary, then you move through after you've considered supplementary aids and services, then you move through continuum, one step at a time, lockstep. And whenever you can, you provide integrated experiences. So in terms of placements do remember FAPE is the primary mandate of the IDEA. So you write the IEP, determine what the program will be, and then look at placement. Do determine if you do think a child needs a more restrictive setting because their behavior interferes or whatever, you first think about supplementary aids and services. And if you decide you cannot provide an education in that setting, you want good documentation that setting doesn't work, and that you will collect data to show the next setting is successful. So use the continuum placements. You start out again with a presumption of neighborhood school, that a child should be educated in their home school if they can, but that is not even close to a requirement. That's just a kind of a very important suggestion. You do determine the placement annually, and if you do have to move children to more restrictive settings, do so by giving some integrated education. Things you don't want to do, you absolutely want to avoid: don't predetermine a child's placement. Don't determine placement prior to doing FAPE or prior to finishing the IEP. And don't consider removing a child from a regular classroom if supplementary aids and services would work. If they won't, you make certain you document that. One of the things that we've had in South Carolina is some schools will say, we have a full inclusion policy, and they just won't even consider other steps in the continuum. That would probably be illegal if it was ever challenged in court. So you don't want to do that. You don't want to exclude parents from the placement decision, and you don't want to just place students based on their category of disability. Now, that's all I was going to talk about. I think the do's and don'ts are very important, and if you want to read the decision, Beth B. Von Clay is the decision that affects you in terms of placement that you might want to look at. It's called Beth V. Von Clay. I will send a copy to Matt. That's really the decision that that any hearing officer, any judge in your circuit, if you have that contentious issue where parents and schools don't agree, that is the decision that they will be using to guide their decision-making or rulemaking. Well, anyway, it's time to go to lunch, so thank you all very much, and we will see you at lunch. Thanks.